July 17, 2012. This is Justice Dunder Cheap. I just want to share with you today the Attorney General's policy regarding public prosecutions. I'm going to read to you this little manual. It's not too many pages, and you get the context or the idea of what the Crown Prosecutor's Office is all about. Now, the introduction states, the purpose of stating the Attorney General's policy in regards to public prosecutions is twofold: to ensure the fair and effective prosecution of criminal and quasi-criminal cases, and to provide public access to the Attorney General's policy and to guidelines issued by the Director of Public Prosecutions under the policy, in order to instill and maintain confidence in the administration of justice in the province. The Attorney General, as a Chief Law Officer of the Crown, is responsible for prosecutions under the Criminal Code, the Youth Criminal Justice Act, some other federal statutes, and all public provincial statutes containing enforcement provisions. Only as a result of statutory requirements or in exceptional circumstances is the Attorney General personally knowledgeable about or directly involved in particular cases being prosecuted. Individual prosecutions are conducted by Crown Prosecutors acting as agents of the Attorney General, who are as such public officers engaged in the administration of justice. It follows that the Attorney General's responsibility in day-to-day public prosecution is discharged mostly by means of general policy direction to Crown Prosecutors in various areas of prosecution that require a fair, consistent approach throughout the province. By tradition and necessity, Crown Prosecutors have a broad and generous area of discretion in prosecutions subject to general policy directions of the Attorney General and specific directions in the exceptional cases. They act under the direct supervision of the Director of Public Prosecutions and Regional Crown Prosecutors. Guidelines issued by the Director are mainly advisory and are designed to further assist Crown Prosecutors in achieving a uniform approach to prosecutions. The major topics covered in the Attorney General's policy are those not dealt with in detail by specific statutory provisions or judicial decisions. Judicial direction. The major topics include policy investigations, alternative measures, and decisions to prosecute, laying the information, private prosecutions, Crown immunity, and resolution discussions. So the first topic is police investigations. Crown prosecutors should always be aware that the conduct of any investigation is the sole responsibility of a law enforcement agency involved. The police do not require authorization from the Crown before commencing an investigation, nor can the Crown direct an investigation or prohibit the continuation of an investigation. The involvement of the Crown prosecutors during the investigative stage, with few exceptions, not required as a matter of law. In practice, however, given the frequent simultaneous application of criminal, evidence, and constitutional law in many of the various kinds of matters being investigated, timely and effective consultation between the police and Crown prosecution is necessary to ensure the proper administration of justice. In this respect, police are requested to consult with Crown in regards to the sufficiency of content in applications for various kinds of warrants. Example, search warrant, general warrants, DNA warrant, body impression warrants, and if circumstances permit, fee warrants that are to be presented to the Crown for authorization. It is essential that the Crown prosecutors be available to provide legal advice when requested by the police. In this regard, it is of the utmost importance that Crown prosecutors be aware that there is a fine line between providing legal advice during the investigative process and becoming unduly involved in these investigations to the extent of assuming control of the investigation. In order to maintain confidentiality and security respecting the identity of persons who are subject to police investigation, Crown prosecutors cannot reveal the facts of ongoing police investigations other than on a need-to-know basis within the prosecution service. Now, the next topic is alternative measures. On completion of a criminal investigation, if the police are satisfied that there is sufficient evidence to lay a charge, but believe that the matter should proceed by way of alternative measures, rather than prosecution, the action will be taken in accordance with the alternative measures program described in the document entitled, quote, Description of Alternative Measures Programs in New Brunswick authorized by the Attorney General, 17th March 1998, close quote. Now the next video will be on decision to prosecute. I'll continue on with that section of the Crown Prosecutors Manual, and I'll take it from there. Thank you for watching. This is Justice Done Dirt Cheap, Part 1 of Attorney General's Policy regarding public prosecutions. Thanks for watching.